So we're going to start with this engagement. If you believe, if you've already heard him before, this is the lead expert of Trust My Assets. And if you're not sure, but you believe you're going to get some powerful information that you've never heard before, and you're going to be able to see something that you've never seen before, but you absolutely need in your life. If you believe that, I need you to put some fire emojis in the chat right now, because we got to welcome him. And let's welcome none other than the lead expert for MWR's Trust My Assets, and that's none other than Mr. Roger Grant. Hello, Roger. How you doing, my friend?
Hey, Dom, I'm doing good, brother. How are you?
Man, absolutely outstanding. I know what's some of what you're going to discuss today, and I'm telling you, they have no idea what they're about to experience, but they're going to be blown away. I won't have to tell them to put the fire emojis in later, because they're going to put it on their own. They're going to do it on their own. But you can see everybody's ready.
All right. Well, I want to thank you for that introduction. You and Brian go overboard, making me sound like I'm somebody special. But honestly, I'm just a guy who came into some financial information that was true information that I'm passionate about sharing because we all need it. Right. So as we're talking about trust tonight, it's interesting that we have something in the news right now with Tiger Woods and his situation, right? So what I want to do is I want to have a trust discussion today. I don't want to do a lecture. We got a couple of slides I'm going to share, but I want to have a discussion about real practical stuff. And some of that applies to you and Gayla. So I'm going to share a couple of slides, and then we're going to wrap this thing up kind of examining what the news is telling us right now concerning Tiger Woods and this little situation with his girlfriend, right? So let's go ahead and if you're ready, Dom, we can go ahead and pull up the slides, or if there's anything that you wanted to talk about before we do.
It's all yours. So you take the wheel.
All right, let's roll. So we've heard this phrase before. This is Nelson Rockefeller, the grandson of John D. Rockefeller and the former vice president of the United States of America. And he says, the key to success is to own nothing but control everything. How do you do that? The only way, the absolute only way to do that is to be the trustee of a complex trust, right? There's only three types of trust. You have all kinds of names for trust, but there's really only three types because the IRS is going to tax you one of three ways: a simple trust, a grantor trust, or a complex trust. You want to be the trustee, the controlling party of a grantor trust. That's what Nelson Rockefeller is telling us, right? So we want to examine some things, and then we're going to have a discussion about real practical stuff, right? Because we don't know what we don't know. Here are the two most powerful tools that we have in business in America. And we need to understand these tools, and we need to apply these tools. The first is a contract. Our ability to private contract is unlimited, and contracts are legally binding. We're going to take a look at that in a minute. The second thing is the proper jurisdiction of law. And most people don't understand that there are several jurisdictions of law in America that you can operate from. The first is admiralty law, which is military, and nobody wants to operate there because you have no rights. The second is statutory law, which is states. And most of us believe we have to function in that jurisdiction because we live in a state, right? Well, the third is the English common law. The whole country was founded under English common law, and the Constitution was written under English common law. So everything outside of Louisiana, which was originally owned by the French, and the law of the land of Louisiana to this day is Napoleonic law. The rest of the country is English common law. So that's a jurisdiction that is available to us, and that is actually the proper jurisdiction of law. When you marry that contract with that jurisdiction of law, you can become bulletproof. So let's go to the definition of a trust, since we're having trust talk tonight. The definition of a trust is a three-party contract in which one can create a binding, inviolate entity. The creator is able to specify the terms, provisions, and who the other parties are. Let's break that down. It's a three-party contract. You have the creator, you have the trustee, and you have the beneficiary. As long as you have those three separate, distinct people or parties, you have a true trust contract. And that is the starting point. You got to get the contract right. And as you see here, it says, in which one can create a binding, that's legally binding, inviolate entity, which means you can't violate it, right? Here's the problem we have with that, is the contract all by itself should be bulletproof, but until you put it in the proper jurisdiction of law, it's not necessarily bulletproof. And we're going to talk a little bit more about that, so I'm going to leave that alone for now. That's the definition, a three-party contract. 3 parties, right? So let's move forward. Talk about this contract a little bit. Here's why that's important. Article 1, Section 10 of the United States Constitution states, in part, that no state shall pass any law impairing the obligations of contracts. What does that mean, Dom? That means you live in California, I live in Texas, and every state in between and on the other side of me, doesn't matter who we put in office, they can pass whatever laws they want to. They cannot pass a law that will impair the obligations of contracts. That's constitutional protection of a contract. Now, this is the courts. Hodgkiss versus Northland Petroleum Consolidated says the courts, however, must enforce contracts as made, not make new ones for the parties, no matter how unreasonable the terms may appear. Dom, if you and I go to lunch one day and we write up a contract on a napkin and it's completely lopsided in your favor, it is what it is. It's legally binding. That's what contracts are. If you've ever watched any of the judge shows, they'll listen to the people come in with their disputes, listen to one party, listen to the other party, and then the first question out of the judge's mouth is, do you have a contract? Because they must enforce contracts. So if the Constitution says the people who make the laws can't pass the law that can impair the contract, and if the courts say that the courts must enforce the contract, for all intents and purposes, that contract is creating law, right? They can't mess with it, and it must be enforced. So getting the contract right is critical. That is something we have to do when it comes to discussing a trust. Now, once you put that contract in the proper jurisdiction of law, remember I said the Constitution was written under English common law, not common law like common law marriages.
Right.
That changes from state to state. So obviously that's statutory. I'm talking about the English common law. Let's see what the Supreme Court has to say about that. It says a trust organization consisting of a U.S. constitutional right of contract cannot be abridged, can't penetrate it. The agreement, when executed, becomes a federal organization and not under any of the laws passed by any of the several legislatures. Crocker versus McClay. Let's break that down. A trust organization consisting of a U.S. constitutional right of contract. We're going to change U.S. Constitution and put in English common law. A trust organization consisting of a English common law right of contract cannot be abridged. Cannot be abridged kind of sounds like the definition of a trust. Binding and inviolate, right?
Right.
Legally binding, you can't violate it. Cannot be abridged is similar language. But it says the agreement, when executed, becomes a federal organization. When we're operating in statutory law, what are we doing? We're operating on state law. This tells you that this entity, this trust, now becomes a federal organization not subject to the law passed by your legislatures. So taking that contract and putting it in the proper jurisdiction of law elevates it above the state, which is important. And I think when we look at what's going on in the news right now with Tiger, I'm going to show you why it's important. I'm going to show you why it appears that maybe he didn't get this part of it right. So before we go there, now that we've covered the contract and the proper jurisdiction of law, I want to have a conversation about a couple practical scenarios, one of which is yours, right?
Right. Mm-hmm.
But I want to share with the rest of the family my first consult with an MWR member who got on the calendar for the experts, so-called experts, that's what y'all call it. And this brother and I got to talking. And he says, Roger, I got a trust last year. Because I need to figure out, am I good or do I need to change it? And I asked him, I said, do you know if it's a revocable trust or an irrevocable trust? And he was like, I'm not really sure. So he started searching around on his computer to see if he could find a digital copy because he was at work and the trust was at home, right? So I told him, because I was thinking we were probably going to have to revisit this because I can't answer that question if you don't have access to your document. So I started giving him some things to look for when he goes home. I said, if you go home and your trust document says the word living trust on it, I said, that's going to be a red flag. That means it's not a trust contract. It's an alter ego. It's an agreement. It's a trust agreement. And I said, and here's why that will be a trust agreement. The definition of a trust is a three-party contract. If you go home and that trust says that you and your wife are the creator, and if that trust says you are the trustee, and then your children or whoever is the beneficiary, that violates the definition of a trust contract. It's got to be a three-party contract. You and your wife will be holding two positions. So there's three positions, but there's only two parties because you guys take up two of those. I said, so look for that. I said, the last thing you can look for is 9 times out of 10, that particular type of trust, your social security number is going to be the EIN number. And he said, okay. And he's still looking. I got a phone call. I had a plumber that I had working from home, had the plumber come into the house, and he was calling me to let me know he was on his way. So I don't want to miss his call. I clicked over, let the plumber know I was home. By the time I came back, the gentleman had found his trust document, a digital copy of his trust. He said, yep, Roger says it's a living trust. My wife and I are the trustees and the creator. And my social security number is the EIN number for this trust. And I sighed because he spent $5,000 to get this trust put in place last year. And he was thinking that this trust had some asset protection capabilities. Here's what I'm going to tell you guys. One, it's not a contract. I already told you how to make it binding and inviolate. Is you got to have a true trust contract. It's got to be three parties. That's a fact. But anything that has your social security number as the tax ID, that's you.
Mm-hmm.
That's you. That's not a separate legal entity because it doesn't even have its own ID. It's you. But the attorney who put this together for him didn't express those things or didn't explain those things. And now the only way around that is to correct it and get a proper trust contract and place it in the proper jurisdiction of law. Now, this past weekend, Dom, you and I and Gayla amongst the room at the workshop, we talked a little bit about what you guys are experiencing right now with her father.
Right.
Why don't you share with the family what we discussed this weekend?
Sure. So my father-in-law has a trust, and he thought, he has everything. He tried to do everything right, everything that he was kind of told to do. And so he put together a trust. He has an irrevocable trust. So he thought he had the right type of trust. However, when we looked at it, once again, what we saw was that it wasn't in the proper jurisdiction because his social security number is on the trust, and him and my mother-in-law were the creators and also the what's the other one? The creator and the
creator and the trustee.
And the trustee.
What they had done was a revocable trust.
That's right. That's right. That wasn't irrevocable. That's right. They have a revocable trust,
which is also the term, guys, for the audience. The term living trust, revocable trust, or grantor trust are all synonymous. They're all the same thing. So they had a revocable.
He had a revocable trust, a revocable living trust. And what he thought and what he believed until this weekend, where we were able to really clarify it for him, and my wife especially got clarified for her, was that he doesn't have any asset protection because he literally made sure that he had the attorneys put his house inside the trust. But there is no asset protection. So if he is one accident, a car, if we let him get behind a wheel and he crash into someone, he could lose all that he's worked for in that one thing, because he would go in thinking, oh, I'm protected, and then soon find out he could lose everything because he does not have that bulletproof trust that he thinks he has. And you ready for this, Roger? We talked to a couple other people, friends of ours that we know, because Gayla has become, she's caught the vision. She's like, gonna be out there telling everybody, singing, hey, make sure you have what you have. But we have another friend of ours. And I don't want to, because I'm not going to say, because people know us, but they do very, very, very well. And they found out they have the wrong type of trust. And they spent a lot of money. In fact, more money, right? And Roger, this is what's crazy. Just like the gentleman you talked about as part of the MWR family, he spent more money than what a singular business trust, to give him that asset protection that he would need with us. He spent more money to get it, the wrong type of trust. That's what's so amazing, and that's why we're so fortunate and blessed that you are here, helping to make sure that as our initials MWR stand for Make Wealth Real, we are starting to get the information that's powerful. And Roger, why don't you touch real quickly, because I'd love for people to, I know we're going to use Google and we're going to have some interaction there, but I'd love for people to understand why even the attorneys they go to don't know this information, and why this information they haven't been exposed to this before.
That's a deep conversation, but the long and short of it is John D. Rockefeller started our United States Board of Education in 1903. And here was the mindset of Rockefeller. These are Rockefeller quotes you can look up. This is what he was thinking when he started the Board of Education. He said, competition is a sin. Number one, I don't want a nation full of thinkers. I want a nation full of workers. So the education system is not designed to liberate you. It's designed to indoctrinate you to what? To not compete with the Rockefellers, the Rothschilds, the Carnegies, and that crowd. To not think like they think, and to work for their companies and patronize their companies. That's what the education system, that's what he had in mind when he put it together. So I want to say in about 1930, and I would recommend everybody listening to this today, if you know an attorney, I want you to ask him this question. When you were in law school, how much time did they spend teaching on English common law? And none of them. I've been asking that question for 10 years. To my own sister and to my spiritual mentor, and the answer was the same: very little. Every attorney I've ever talked to over the last 10, 11 years, they don't teach it. So how are we going to get information when the highest authority, people who have a Juris Doctorate, a law degree, don't learn English common law? That's why I say all the time, Dom, there's two sets of financial information in this country. One set of information is given to the public. The rest of it is passed down. It's usually passed down amongst the bloodline. And they don't share it with anybody else.
Right.
I was just fortunate enough to meet somebody who had been in that arena for 25 years. And I told him, if you're willing to teach, I'm willing to learn.
Right. And so that's why, but what you said, and that's why not only do they not want to teach us it, but they certainly don't want us to do what they do.
No.
And now we're in a unique position here at MWR, and you're leading everyone to help them do what not the wealthy elite do, because you're about to talk about someone shortly here who's wealthy, but wealthy elite is another level, and we are starting to do what the wealthy elite do, ladies and gentlemen. So again, if this is some great information, I've been seeing a lot of people put in the chat, it's great information. We need to get some muscle in here and talk about how strong this is. So put that in the chat.
Don't flex on them. Don't do that.
Yeah, we got to flex on them.
Well, before we flex into that wealthy elite arena, let's prove some things, right?
Right.
Because y'all gonna hear me say this all the time: documentation beats conversation all day, every day, and twice on Sunday. So what we're gonna do is we're gonna Google some simple information that every one of you can do that. We just got to know what questions to ask when we're dealing with these attorneys or with anybody. So what we're going to do, Google, is, does a living trust have asset protection capabilities? And if we can make that a little bit bigger so they can see, can we make that full screen? There we go. Let me read this for you. You didn't even have to click on a link to find this. It's right there. And I'm hoping some of you at home are doing the same thing. Does a living trust have asset protection capabilities? And it says a living trust does not protect your assets from a lawsuit. Living trusts are revocable, meaning you remain in control of assets and you are the legal owner until your death. Because you legally still own these assets, someone who wins a verdict against you can likely gain access to these assets. Now, my name is not on that definition nowhere. I didn't print that. If you keep scrolling, you're going to see there's several different explanations, and they're all telling you the same thing. And we don't need to do that now. But I promise you guys, Google that for yourself. There's information all around us. We just need to understand what questions to ask and the language to speak. There is no asset protection if you don't have a proper trust contract. A proper trust contract creates an irrevocable trust. And let's talk about that for a second. Irrevocable is only irrevocable to the creator. So here's what I need you guys to understand. When Nelson Rockefeller said, the key to success is to own nothing but control everything, the only person who has control is the trustee. So he's telling you something. You want to be the trustee. It doesn't matter who the creator is. You can have a loved one be the creator. Anybody can be the creator, because once the trust is created, it's irrevocable to the creator. They have nothing else to say about it. The trustee can put assets into trust, take assets out of trust as you see fit, because you have what? Control. So getting that contract right helps you to, the key to success, what he said, was to own nothing, control everything. You have to be in the position of control without having a position of ownership. And what that definition just told you, if you hold those two positions, you still own it. So you can put your car in a trust, or you can put your house in a trust, put all your assets, your money, everything in a trust. Go get in a simple car accident and everything you own is at risk. And that attorney who charged you, and they typically charge $3,500 to $7,500 I've seen for the wrong stuff, they're just not going to tell you. And I don't know if they know or not. I'm not going to speculate on what their knowledge base is, but I know 90 to 95% of trusts out here are living trust. And that's, if you know anything about trust, you've heard that term, because that's what they put together. We don't do that. You're going to have a true trust contract here. And it's going to be in the proper jurisdiction of law. So now that we're done with the revocable living trust and the fact that it's not a contract, we're going to talk about having a true trust contract, but not having it in the proper jurisdiction of the law. Let's pull up that the slideshow so we can take a look at Tiger Woods' situation. So we saw on the news, and it doesn't say it on this slide, but his ex-girlfriend is suing his irrevocable trust. What does that mean? Tiger Woods has a true trust contract. It doesn't say if he's a trustee or not, but it is a true trust contract. It's irrevocable. So the argument here is that they had an oral agreement. Now, here's the thing. A trust is a written contract. A common law trust is what they call an express trust, written in common law. It has to literally say you can do a thing before you can do a thing. And trusts don't have oral agreements. They don't. So if the trust itself owns the house, Tiger doesn't own the house. Him and the trust are separate legal entities. It's not an alter ego. He doesn't own it. The trust literally owns it. So he's just a tenant. If that contract isn't written out to say she can stay there for 5 years, It's not in the contract. She can't stay there. That's not, trusts don't make oral agreements. It's a written document, right? So the trust by itself, because of the Constitution, says lawmakers can't pass laws to impair the obligations of contracts. And courts must enforce contracts as written. So if that trust document didn't physically write out and express that she can be there for this 5-year period, this oral arrangement that she has, if it ain't written, then she has no leg to stand on. Now, here's the issue. If that contract is not in the proper jurisdiction of law, sometimes we have, not even sometimes, oftentimes in this country, we have judges who want to legislate from the bench. They don't necessarily follow the Constitution or court precedent. And when they make decisions, the state judge is the authority for the state. So let's examine this little picture that we have on TV. And I want everybody to peruse over this and see if you see anything that stands out that suggests maybe Tiger isn't in the proper jurisdiction of law. Wood's ex-girlfriend's lawsuit over residency. Here's the claims in the lawsuit. 5 years in, oral agreement to live, expenses paid, right? Locked out after being told to pack suitcase for short-term vacation. Confronted by lawyers. $40K in her cash, misappropriated or whatever. I want $30 million. That's the bottom line of all of this. I want $30 million. Now look at the very bottom of this. Look at the very bottom. It says Martin County, Florida, Circuit Court filing. So this suit was filed at the county level. What did it say about a trust? This is a second case that I'm going to read you about a trust. It says, right to contract cannot be abridged. The agreement, when executed, creates a federal organization. Same words we heard before, abridged and federal organization. Not under the laws passed by any of the several legislatures. That's Boyd versus U.S. The first one I read you was Crocker versus McClay. Said the same thing, cannot be abridged, and it's not subject to the laws of the several legislatures. So if it's not subject to local law and it's a federal organization, it should not be in a county courtroom. So here's what we're going to see. We're going to learn some things real quick here. If this trust is placed in the proper jurisdiction of law, it's going to get kicked out of the county courtroom. They're going to have to take it to a federal courtroom because that trust is a federal organization. If this case continues in Martin County, it's because Tiger put together a solid trust contract and did not place it in the proper jurisdiction of law. And we're going to have to see if this judge is going to legislate from the bench, because a trust doesn't make oral agreements. Tiger might have made, but he don't own the house. The trust owns the house. So we're going to see what jurisdiction he put that trust in. All this is going to play out on TV in front of you. Now you'll be able to follow it. We're going to find out if he put that trust contract in the proper jurisdiction of law. And we may see how damaging it can be if you don't have it in the proper jurisdiction of law. And I'm going to give you one quick example of this, and then we'll have a conversation done. I have a friend, when I first got started doing this, she's from Beaumont, Texas. Beaumont's where the first oil well in Texas was drilled. She was a regional CEO for Keller Williams Real Estate. And because she's down there, Beaumont's old money, old oil money, right? She knew some stuff about trust. She knew about a business trust, and we had this conversation. She said, Roger, could you come down and do a presentation for my agents about minimizing taxes through proper structure? I said, yeah, sure. Went, did my presentation. Afterwards, she was in the back of the room looking kind of perplexed. And she said, Roger, you do have to leave right away, or can you hang out for a little bit? There's something I want to run by you. I said, no, I don't have to go anywhere. What's up? Went in the office. She closed the door. I'm like, okay, this is serious. What's going on? She said, I want to tell you what happened to me when my husband died. She said, we put together 3 trusts for our boys. They had 3 children. Her mother was the creator on all 3 trusts. She was the trustee on all 3 trusts. and each boy was a beneficiary on their own trust. Proper, irrevocable trust contracts, 3 separate parties, binding inviolate entity, which is what the contract should be, all by itself. But she didn't know anything about the proper jurisdiction of law. Her middle child grew up, and when he turned 18, he had a drug addiction. And he didn't agree with his mother about his inheritance. And so he went and got an attorney, sued his mother, found a judge down there in Beaumont who agreed with this child and revoked his irrevocable trust contract, gave this kid $500,000, of which he blew, I should say, every dime in less than 12 months. Here's a mom who just lost her husband, trying to look out for her child and knowing he's not in a position to manage that kind of money. And this state judge, because the state judge is the authority for the state, decided he was going to do something the Constitution said you can't do. The courts say, court precedent says contracts must be enforced as written and not altered for the parties, no matter how unreasonable the terms may appear. I don't care if this kid thought what his mom was doing was unreasonable or not. It's an irrevocable trust. It cannot be revoked. But when you're at that state level and you get a judge who wants to legislate from the bench, you're not always going to get an appeal. And if you do get an appeal at the state level, that judge who just made that decision is going to be part of the appellate team.
Right.
How likely are they going to be to override him when he's a part of the panel? You got to come out of that jurisdiction. And I would say by the end of next week, we will understand if that filing in the county for Tiger stays there, because I'm gonna tell you now, all he's got to do, if it's written properly, is challenge the court's jurisdiction, because they do not have jurisdiction, and his ex-girlfriend is gonna have to take this to the federal courts because this is a federal organization. So we're seeing some stuff play out right now on television that's going to be very interesting.
So Roger, let me ask you this, because especially in light of what the young lady experienced and the judge making that ruling, and if you put the Martina, if you put the Tiger Woods picture or that slide back up for us, so essentially a judge, if it's in the wrong court, if we find out that it stays in the Martin County environment, it stays there, so we now know he's in the wrong jurisdiction. A judge could just go, well, Tiger makes a lot of money. I feel for the girl, even though he has a contract that says something completely different. I feel for her. So yes, we're going to honor. We're going to. He may not get the whole 30 million, but we're going to give her 10 million, and just make that ruling. And if he tried to appeal it, what you're saying is that same judge is going to be on the appellate court, trying to determine if that's going to get overridden. The other judges don't want to play with that, so they're going to probably let it stand. And then Tiger, even though he did a trust, try to do everything right, because of the wrong jurisdiction, he could be out some money when he went. Otherwise, he wouldn't be. Now, let me ask you this question, because he still could get sued if he had this suit could still be brought if it's in the proper jurisdiction. And it, like you said, it get kicks to the federal. And first of all, a lot of attorneys don't want to deal with federal because they never had to do with federal court and things like that. But let's say that happened, and now they go and they're going to try to federally do it. And if a judge tried to legislate from the bench, as you call it, make their own decision and not appeal to what the law says, in the federal court, you told me something else happens, which was why your trust becomes bulletproof. Why don't you explain that?
Well, at the federal level, you're going to start with a single judge. You're guaranteed to be able to go to the appellate courtroom where there's 3 independent judges, not the dude who made the decision. And they hold each other accountable to the law. They're not looking at the judge who made a bad ruling sitting next to them as they're judging your case. It's 3 independent judges, and they hold each other accountable to the law. It's just a safer jurisdiction. Now, that doesn't mean you can't lose. You do something wrong, they take it to the federal courtroom, and they make a decision, you appeal the decision. The 3 judges might say, but it's a whole nother level of competition, and you have very few rogue federal judges. We have so many rogue state judges, it's ridiculous.
Right. So that being said, this is why it's so critical. And I'm glad you brought this up and brought it to the case, because we get to see, as you said, we get to see this played out in a courtroom to see exactly what's going to happen. So everybody stay tuned. Now, we had a few questions, Roger, and I know we're getting close to the end here, but we had a few questions.
Before we get to those questions,
yes.
I want to say one more quick thing, right? Because there's levels to all of this.
Right.
Guys, this is all about asset protection and succession planning, right? So the lowest level is to do nothing, assets at risk all the time, and when you die, you end up in probate. The next level up from that is a will. And I'm here to tell you, a will means you will be in probate.
Right.
Because it's not a contract, all somebody has to do is say, I don't agree with that. I disagree. I'm challenging this will. I like to say this, a will is an express invitation to probate.
Right.
It really is. But it's something. It's better than doing nothing. But 9 times out of 10, it's going to end up in probate. Then you have the revocable trust. And though it has no asset protection capabilities, it will avoid probate, guaranteed. That's the next level up. Then you have the revocable trust that has asset protection capabilities and it will avoid probate. And then you have that same irrevocable trust in the proper jurisdiction of law. Now you become bulletproof. So there's tiers, there's levels to this. Doing nothing should never be an option. If you don't do anything, get a will. But understand, once you leave here, your stuff is probably going to be caught up in the probate court.
Right. So no, if you know better, you should definitely do better. So we had a couple questions. In fact, I'll just tell you, Ebony Williams said that she had ran a company for 18 years and kind of experienced a little bit of what your young lady did down in Beaumont. So she understood where you were coming from. And Cindy Lukehart said, man, she wished she knew this 15 years ago, which I understand. I'm right there with you, Cindy. And then, but we had someone.
I was 40 when I found that. I sure needed it at 30.
Right. Exactly. Now, I had someone ask a question, and their question should have been answered, but I'm going to ask it because I know people sometimes when they're getting messed up with the jurisdiction. So I know the answer to this question, but I'm going to ask it anyway. It says, is a trust in Wyoming the best place to put the jurisdiction? So I know they're thinking, oh, if I have it in Wyoming, and I know some things about Wyoming, why people want to go there and get an LLC and those kind of things. But if I go to Wyoming and I have my trust there, if I have it in Delaware, or if I have it in Las Vegas, in Nevada, the state of Nevada,
that's right.
Is there a difference for me? And go on and answer what you've said consistently, but say it again.
So you have people who desire those jurisdictions, Nevada, Wyoming, Delaware. They're good jurisdictions for an LLC, for a statutory entity. Guys, we operate above the state, above it. When your trust contract is put together and notarized, it's a federal organization. It's not registered with any state. No state. That's it. Above the state. So that's the goal, is to get out of that jurisdiction completely, not to find the best in the lower jurisdiction, but to rise above all of that completely.
Now, another great question, and you're 100% right. Another great question I love, and I learned something about this weekend to help me even have clarity. But do you need a CPA and a bookkeeper to kind of manage the affairs of the trust? Is there a lot of paperwork that goes on? You see, Mr. Mark Jackson asked that question.
Yes, I saw that. No, you do not. You might have a CPA who files for you. We have enrolled agents who will file your 1041s for you if you need help with that. But as far as accounting goes, no, we don't have to itemize. So I don't have to keep receipts and do all this other stuff. We don't have to do any of that. Basically, your bank statement is going to be what you use to calculate your taxes. Whatever came in is income, whatever went out is an expense.
There you go. Okay, I love it. One other thing, another question I was asked, someone said, can I own the house? Okay, if I have a house, like Tiger has a house, but let's say it's not paid for, it's not completely paid off. Can I still own the house, put it in the trust when it's not paid off? Do I have owners, or does my trust now have ownership of that house?
Yes, and I'm glad you saw that question, Dom, because I was going to bring it up if you didn't. So can you put a house in a trust even when it has a mortgage on it? You absolutely can. Yes, you can. And I'm going to tell you some things, but I'm going to tell you practical experience that is different. Every mortgage contract, every one of them says due on sale clause, right? If you deed the property into somebody else's name or even into a trust, they say they have the right to call you to pay the mortgage due on sale. That's not a sale. You own the home, you're holding it somewhere else to protect it. And I was in the mortgage business for a decade. I used to deed people out of properties because they will not lend to the trust. So if you want to do a refinance or something, you deed the property back into your name, close the loan, put it back into the trust. Do it all the time. My sister was in the mortgage business for 30 years. She was with a nationwide company. They had a whole department in Colorado that did nothing with what I just said, deeding properties in and out of trust for people to do refinances. The bank wants their payment. That's what they care about. Now, if you put it into the trust, and I've never seen this happen, and I don't think it ever will happen, and the bank said something, just deed it back into your name. Now it's not sold, but you're never going to have that issue. So yes, you can put a property with a mortgage into a trust.
Okay, and these next two questions, I know Katrina had one, Bridget had one. They're different, but they're basically the same. Katrina, as you can see on the screen, is asking, should a person who inherited a property have a trust? And then I'll just tell you the other question is, Bridget asked, if you have an irrevocable trust, is that the best way to protect your assets? I know they're similar because the answer is going to encompass both sides of what they asked there. So
yes.
Why don't you share it with us?
So the first question, if you inherit anything or whether you build anything, if you go buy a house or you inherit a house, that's an asset that you don't want in your name. And the question that you have about a trust is, if the asset you're looking to protect is valuable enough to spend for MWR $2,500, like for example, if I have $50,000 in the bank and it's going to cost me $2,500 to protect that 50, does that make sense to you? Then it's time to get a trust, right? If it doesn't make sense to you, you might wait till it's 100,000 and say, okay, now I want to spend the money. Whatever makes sense to you, you got to make the expense of a trust worth the value of what you're protecting, whether it's a house or anything else. Okay, that's a personal decision. And the second question there, Dom, was
if you have an irrevocable trust, is that the best way to protect your assets?
It's the only way to protect your assets because you don't own it, but you fully control it. That's what Rockefeller said, right? The key to success is to own nothing but control everything. Only way to do that is to be the trustee in an irrevocable trust, a complex trust.
But there's one little tweak, if you will, of that answer, right? Because they can have an irrevocable trust, but like the young lady you spoke about in Beaumont, Texas, the CEO of her Keller Williams environment, but if she has it in the wrong jurisdiction,
yes, ma'am,
then she can have exactly what happened to her, which ultimately her son lost his inheritance, even though she was trying to do the right thing for him. Correct. Is that correct? Okay.
That is absolutely correct.
So what I want to do is this, Brian, because of the questions, and I know where people are going and they're trying to determine, and I know what they're thinking, do I have the right trust? Or if I go get a trust, just go get an irrevocable trust and I'll be good. Help them understand that this is not just information, but MWR has Trust My Assets, and help them understand what that is, what that division is going to do for the MWR family.
Well, Trust My Assets, I've put together a couple of webinars for you guys for two reasons. One, to just understand protecting assets and what a trust does in that arena. There's three different stages of life that we have to deal with in protecting assets. When we're living and we're doing well, like the gentleman I talked to, the first MWR client, he's doing well. He got a trust from an attorney thinking he was going to protect the things he's building, right? Then we have the stage in life where we may be living, but we may not be doing well. And you may need help from the government because long-term care is extremely expensive. If you own things, the government will not help you at all in any way, shape, or form until you sell everything or you're destitute. If you have a proper trust, You can put all of your assets into a trust, and what the government is going to do when they look at you, depending on what state you're in, they're going to do a 3-year or a 5-year look back to see if you gave away or sold assets. You can be in your house as a trustee, controlling that house, living there, and they can't say you own it. So it positions you when you're not doing so well, but you're still alive. And then a trust will protect you when you pass, because it will bypass probate. And because it is a contract that can't be penetrated or changed or challenged, what you say needs to happen will happen when you pass. So that's one webinar we put together. The second webinar is how to fully structure a business. If you're making $70,000 or more in income, whether it's within MWR or any business, how we can literally reduce your tax liability to 5% or less, filing all the proper tax paperwork with full disclosure.
Right. So I'm going to leave you with this final question. And obviously you can help people do that, but one person had something, and I thought it would be interesting. They said, can you have a trust that develops, can you have a business that develops business credit, and they can kind of have business assets, and can that be put into a trust, and can that continue to grow those assets and credit inside of a trust?
Yes. So
and again, I'm going to say, before I do this, I want to make sure I say a properly structured trust, because we got to make sure we keep that first and foremost.
Yes, sir. So every trust is going to have its own bank account. So he's asking if a trust it has to have a bank account.
Right.
Right. So that's why it has a tax ID number that's not your social. It has its own ID number, which means it needs its own bank account. Right. In terms of establishing trust credit for the trust, that's a lot more difficult than it is for an LLC, for one of those statutory entities. So I typically tell people, if you want to get business credit, do it in the LLC. Just make the trust a member of the LLC. Same thing is accomplished. Trust is owned in the LLC, but it's easier to build credit for a statutory entity than it is for this federal organization.
All right. And this is a final question, everyone. I know you keep putting them up there, but final one. If you have a house and it's in the trust and you decide to sell the house, do you have to take the house out of the trust before selling it?
Question is, do you want to pay taxes?
Right.
If you pull the house out of your trust and you sell it in your name and you have a large profit, that tax bill is on you. If you sell the house in the trust, the money comes back to the trust, and we put the proper structures in place to make sure you don't pay taxes on the sale of that house. So this is what Rockefeller said. The key to success is what? Own nothing. You don't want to have things in your name, but you want to have full control. Leave it in the trust. Let the trust be responsible for the taxes. Here's why Rockefeller said that. There's liabilities to ownership, guys. Anything you own can be taxed to you and taken from you. So the goal is not to own things, but the goal is to control things. If you don't own it, they can't tax it. They can't take it.
Well, Roger, I'm going to tell you again, phenomenal night. If all of you are feeling this was information beyond what you even expected, you know what to do. Go put it in the chat. Let Roger know. Let him feel the love. But Roger, I also want to let everyone know the process. So all they do is they go into Trust My Assets, and then they're going to pick a path. If they just want to, like you said, if they just want to protect their assets, and that's all they're looking to do right now, then they can go and watch the video, because it's required, just so everyone is clear, it's required to watch one of the 2 videos before you ever get to set the consultation. So you'll watch the video, and then you'll go on and put the information in that's being requested, and then you'll be able to schedule your consultation with Roger and his staff, and they'll be able to walk through whatever your specific situation is, get all your questions answered, and get you in the proper jurisdiction with the properly structured, complex, irrevocable trust. Now,
can I add something to that, Don, real quick?
Mm-hmm.
Guys, please watch the videos. Pay attention and focus on the videos, right? Because when we get to your consultation, I don't want to talk past you. You know what I'm saying? The information, this is about understanding, right? Because even if we put the trust in place, if you don't understand what you have, You might be able to protect it while you're here, but you're not going to be able to tell your next generation what they need to do to maintain what you put them, the position you put them in. So watch it diligently. If you got to watch it a couple times, so when we have our conversation, then you can ask questions that are pertinent to your situation that will stick in your memory because you understood the information that was put in the webinar.
Okay, no, perfect. And so that leads to the other, if you want to structure yourself completely so you can minimize your taxes and pay 5% or less, then you'll watch that video, which is a very different video than the other, because it's going to have everything you need to know to be prepared to have that conversation with Roger, as he said, so he's not speaking over your head. So make sure you do that. One of the things that is so powerful to what Roger does, and a lot of times we think, and because especially if you've gotten trust on your own before, you already know this. You think that, oh, and once I get the trust, I have it. That's all I need, because that doesn't happen here at MWR. At MWR, Roger does not get paid to put the trust together. What he's getting paid for is the ongoing consultation. So you know that now I have this entity, what and can I do with it? How can I operate within it? And I will tell you from the workshop that I just experienced for my own self. So that's why I have my family there. My son Enrico and my wife were there. It is to make sure that we understand what freedom is. We've been so indoctrinated and conditioned to live a certain way and ask for permission on all kinds of things. What Roger did this weekend is help us understand we can do exactly what we want to do, how we want to do it, when we want to do it, because we operate in freedom under that structure. So know that. Understand that you're getting consultation, and as long as you're an active member of MWR, you'll be able to continue to get that consultation, which is worth way more than what your initial investment was to get the trust put together. So just recognize that. With that, I think we're all saying thank you to Roger. I saw some fire emojis. I saw some.
Let me say one last thing.
Go ahead.
Before you get to flexing on them. In regards to what Don was saying, we've been indoctrinated. We've been taught to ask, can we? Right? When you understand truly what a trust is, and think about this. If the Constitution says the people who make the laws can't pass a law, they can mess with your trust contract. And if the courts say that they must enforce the contract, all by itself, the contract should be bulletproof. But once you put it in that proper jurisdiction of law, you're not asking anymore, what can I do? You're more so figuring out, what do I want to do and what's the best way to do it? That's the freedom we got to step into. And it takes some time and it takes some practical application, but then the light bulb goes off and you recognize that contract, it's called the governing instrument. Your trust document is called, the IRS will call it the governing instrument. What does government do? What does a governing instrument do? It governs. They don't get to govern how we operate. We govern how we operate. And when you're the governor, who you got to answer to? I'm going to leave it with that.
Well, I'm going to leave that. And everyone, thank you so much. Thank you for thanking Roger, because he did a phenomenal job. We're going to have him back here again in a couple of weeks, so you'll be able to hear from him again on some other information. So with that being said, we're going to say thank you. We're going to wish everybody a good night. Let's go make a difference in people's lives. Continue to bring people into MWR so they can make wealth real for them and their families as well. Thank you so much. Have a great night, everyone.
Right on.